Good afternoon, everyone. Welcome back to Senate Education. It is Friday afternoon, February 26th, and we are looking at H81, which was sent to us by the House last week. We have with us Representative Walz from, am I pronouncing that correctly, Tommy?
Yes, pronounced just like the dance.
Okay, Walz, perfect. From Barry Town? Berry City, thank you, who I believe reported the bill on the House floor. And we have invited the representative in to give us an overview of why his committee took the bill up, the genesis of it, and your interest in us continuing that work. So with that, Representative, the floor is yours.
Okay, well, thank you very much. I'm going to refer now and then to some remarks that I've written up. I thank the committee. I am Representative Tommy Walz from Berry City. I'm here on behalf of the General Housing and Military Affairs Committee because we're the committee of jurisdiction for collective bargaining bills. And that's where why we had H81. H81 amends Act 11 of the 2018 special session. And what that act did was to create a 10-member commission to deal with negotiation of healthcare benefits for school employees. Okay, so that was back in 2018. And there are all kinds of details in that act we don't need to go into, but that commission was created. They did hold a round of negotiations. There was, for the very first time, a statewide agreement reached on school employee healthcare benefits, and that is now in effect. The next round of negotiations actually begins on April 1st. It's coming up. So there was a little bit of urgency in some pieces of this, but we're going to be okay. I think we've designed this so we don't have to worry too much about that April 1st deadline. I want to point out a couple of things before I get into the bill, and I'm only going to deal with a very high level look at the bill. First of all, I've been involved in school negotiations myself 4 times, twice as a union rep and twice as a school board member. And so as a result, I kind of know what's going on both sides, and I have a very deep faith in the negotiations process and a deep respect for that. And I really think that's an important piece of what we are dealing with here in H81. And I also want to stress, excuse me, it's my daughter sending me a message. I want to stress that H81 is a collective bargaining bill, and that's why we got it in our committee. It is not a healthcare bill, else it would have been on the healthcare committee. Okay, and so I want to be very clear on what 81 is about and what it's not about. It's not about healthcare, it's about collective bargaining. So they did negotiate under the terms of Act 11. And after the process, both sides agreed there were some flaws in the act, and they thought there should be some changes. And the Senate actually tackled that last biennium in S226, which I'm sure your committee looked at. I haven't looked at the entire history of 226, but it came out of the Senate with very strong support. I think it may have been unanimously voted out of the Senate. If I'm not right on that, I know it had extremely strong support.
Yeah, I think you're accurate there, Mr. Representative.
Right. So first of all, this is not going to be brand new territory for you. And secondly, you know that in the past, there was a lot of support for it. H81 as introduced is S226, word for word. It is S226. It came to our committee, and of course, it's no longer as introduced. We have made many changes to it, many amendments of varying degrees. And I know Legislative Council is going to walk you through the bill and you will see all of those changes. I would like to highlight two changes that are significant in my high-level view of this. The first change is the inclusion of the Vermont Labor Relations Board as a potential arbitrator. In Act 11, it specified that there would be, if it reached that point, one arbitrator to be provided by the American Arbitration Association. What we have done is to add some flexibility to that process. And we've allowed three possibilities: to either have the one arbitrator or to have a three-member panel. And that three-member panel would have one member appointed by the employee side, one member appointed by the employer side, and the third member provided by the American Arbitration Association or the Vermont Labor Relations Board. And the Vermont Labor Relations Board was part of this discussion, and they are okay with that concept. So that is one major change that we made in the arbitration process. The other major change that we made, we think is more important, and we think it helps to protect the lowest paid employees. For bargaining purposes, school employees are divided into two groups: licensed employees and unlicensed employees. As licensed employees, we have teachers, supervisors, administrators, and so forth. In the unlicensed group, you have paraprofessionals. It can vary from district to district, but it can be the paraprofessionals, it can be the cafeteria workers, the bus drivers, custodians, and so on. Clearly, those are very different income level groups. Unlicensed employees earn about 40% on average of what licensed employees earn. That's a huge wage gap between the two groups. And traditionally in school negotiations, those two groups have been treated very, very differently, both dealing with salary, obviously, but also with health benefits, working conditions, and so on. And so it's been a very cognizant, and in my experience, both for the school board and for the union, it's been a clear separation. Currently, licensed employees typically pay 20% of their health care premiums, and unlicensed employees typically pay 15 to 16% of the health care premiums. And that's in recognition of the different income levels. It's recognizing that unlicensed employees just don't have that much disposable income. Also, traditionally, there's a big gap in the out-of-pocket expenses. Unlicensed employees have traditionally been required to pay several $100s less in out-of-pocket expenses than licensed employees. Well, there was an issue in Act 11. Act 11 stipulated that all employees would eventually be treated the same, that all employees, regardless of which group they fell into, would pay the same premium share and the same out-of-pocket expenses. We found that in our committee to be contrary to past practice and patently unfair. If that went into effect, unlicensed employees would face a financial triple whammy. They would have one, an increase in their premium share; two, an increase in out-of-pocket expenses; and three, the regular increases in premiums. So this has been pitched, and you're going to hear this argument, that doing that mandate, that everybody pay the same out-of-pocket and the same premium share, is a cost-cutting measure. And I find that wrong on a couple of levels and for a couple of reasons. First of all, is that neither the employees nor the employers have any control over the premium levels and the increases in premiums for health insurance benefits. Next year in FY22, the average VHI plan is going to increase 11.58%. One of the most popular plans is going to go up over 18%. I would argue if you want to control costs, that's where you got to look. And that's part of the reason why I think the argument that, the mandate is a cost-cutting measure. And the other reason is that it's just a matter of practical logic. Let's say as a General Assembly, we decided we needed more revenue from the income tax. And we decided the way to do that was to put a surcharge on the income of everybody earning less than $25,000 a year. Totally illogical. But that is in effect what Act 11 would do. It would put the burden of this cost-cutting measure, in quotations, on the very lowest paid employees. And we think that just does not make any sense. We want to protect them. So Act 11 is a pretty radical idea, the whole idea of negotiating statewide. When I first negotiated in Vermont back in the 60s, this was a concept being floated around that we would negotiate on a statewide level. Well, it only took 50 some odd years to get there, but Act 11 did that. So when and both sides, decided when they used the process that there were flaws. And we think the biggest flaw of all is this one, is the mandate that treats licensed and unlicensed employees as if they were on the same financial footing, which they clearly are not. So we recommend that you take a good look at H81, that you pay special attention to that particular issue, the mandate. And I want you to know that it passed out of our committee on a 10-1-0 tripartisan vote. And in the House, it passed 96-36, largely a tripartisan vote. So what we've done with H81, and it changes Act 11 by adding transparency, and you'll see when Ledge Council goes through that with you, what I mean by that. It also adds some flexibility and, most of all, fairness. And we really hope that you will help us in protecting the lowest paid class of school employees as you consider the bill. So I'm here if you got any questions. I thank you for the consideration.
Sure. Senator Perschlick.
Sure. Representative Walls, one of the issues that came up last year on S226 was this issue about cost containment that the arbitrator has to consider. And,
right.
How did your committee, address that issue, or, how is that dealt with now in your bill compared to Act 11?
Well, in what sense we didn't have to do anything with it because it's already state law that the arbitrator must consider 5 financial considerations. One complaint that both sides had about the past process was the arbitrator's decision did not enumerate what they had considered and whether they had considered that. So we have made that change in H81. We have specified that the arbitrator's decision must specify that these issues have been addressed.
The cost issue.
So the arbitrator must be clear on what he based his decision on.
Okay. And what was the vote? You gave us the vote in the committee. What was the vote in the House, or did you say that?
The committee was 10-1-0, and the House was 96-36.
Senator Chittenden.
So nice to meet you, Representative Waltz. Thank you for that walkthrough. I believe that all the members of this committee have received a few correspondences from school boards over the last week or so. The multiples have a specific amendment that they're asking us to consider, which I just pasted into the chat of this window. I think I've been following what you've been saying, and some of it is connected with this, but is this language something you're familiar with that your committee directly addressed, or do you have any thoughts on it, or is this new to you and something that is just surfacing or bubbling since this bill has passed through the House?
Okay, I'm ready on your chat right now. And that wording is a little bit different, but it is in the bill. It's not worded the same way.
Does it have actuarial value in the bill? I mean, because doing an actuarial analysis is quite expensive.
Senator Lyons, if you could explain what you mean by that, by the actuarial amount.
Well, I'm looking at that proposed amendment that Senator Chittenden sent out to everyone, and little a 2A says the actuarial value of the health benefits for the full term of the award. So if you do an actuarial analysis can be costly, and if you're doing two separate analyses, one from each side, that's very costly, I would think. And I mean, I'd leave that up to Jim to help us with that, or, yeah.
Yeah, that language is not what we currently have. And I'm not sure what they're trying to get at there. Because the language we have says each side must reveal the full cost of what they're proposing.
Yeah.
And I don't know if that gets at the same thing or not.
It's probably slightly different if you're going to look at relative values, but
So if I may, Chair?
Please.
That's what I'm struggling with, Representative Waltz, is I feel like what's in the bill is getting at this, but I'm not a lawyer. So Jim Demaray, I don't think we're voting on this today, but when we come back, I would love to know how you interpret this language, and Senator Lyons highlighting that actuary value. That's really helpful to know that you understand the cost implications of it. But this is what's in my inbox, and I was hoping to better understand how this language might or might not be attractive as a slight amendment.
I agree with you, Senator Chittenden. That's a good lawyer question. But I think we've got pretty plain language in the bill that they have to reveal the full costs of their plans.
Other questions for the representative?
I guess.
Please, Senator Hooker.
Sure. Thank you. And thank you, Representative Waltz. So you said that this isn't a healthcare bill, but it's a collective bargaining bill.
Right.
So can you, does this bill in itself have costs?
Yes, there is an appropriation because the members of the commission are entitled to per diem and expenses. And one of the things we did do, we doubled the number of allowable meetings from 10 to 20. The original appropriation was $17,500. So we've doubled that to $35,000 to cover the maximum allowable per diem and compensation. Now that does not mean that every member of the commission gets it. For example, on the employee side, they're entitled to release time. And if that release time is paid, then they're not entitled to the per diem and expenses. So what the actual cost will be, we don't know, but the appropriation is $35,000.
But this bill itself would allow lower paid workers to negotiate their health benefits separately from licensed workers?
I'm going to be careful on phrasing that. The employee side is 5 members on each side, okay? Mm-hmm. And on the employee side, there are 2 unions representing the licensed and unlicensed employees. And so they have representation on the commission. It's not like there's an unlicensed group of commissioners and a licensed group of commissioners. I just want to make sure you're clear on that.
But the negotiation would allow separate out-of-pocket expenses, separate premium costs and percentages.
As is the practice now. Yes, it would just continue current practice.
And this happened in the first round? This happened in the first
Yes, there's still a differential. I know the attorney can correct me. I think the timeline in the original bill was 2024. That was the mandate that they would have to be paying. I might be wrong on that year, but I'm sure the attorney can help me out on that. And the original plan was to increase them 2% a year until they had reached, I guess you'd call it parity, but it really isn't, since they have very different income levels.
Okay. Thank you.
Senator Lyons.
No, my question is, did the bill go through appropriations? Obviously, there's some money in here. And did they approve, are they going to put this into the budget, or has it been put somewhere already?
Appropriations approved it. I'm not sure.
Okay,
It comes out of the education fund, I assume. And I'm not sure. They just added it. I don't
yeah,
know. that.
probably,
I'm sorry.
okay. Yeah, so that'll be true, that'll true up when the big bill goes forward. Okay.
Any other questions for Representative Waltz? Okay, thanks for being with us. Really appreciate it. Great to see you. And we're going to turn it over now to our Ledge Counsel to take us through the bill. Again, as a reminder, this is walk through and get a basic understanding. I think everybody's inbox is being flooded with emails. So this will hopefully guide some of our work and help the committee make a decision with regard to what direction we want to go in. Okay.
Thank you, Mr. Chair. And yes, our committee, we got more emails on this than anything else.
Okay.
So be ready. You're going to
Okay.
get flooded. And thank you for your consideration.
Yeah, thank you. Have a good day. Okay, Mr. Demaray.
Okay, so what I've done is I've prepared a side-by-side to show you S226 as it was passed out of Senate last year versus H81. So you can see the differences. Would that be helpful to go through that?
It's I don't know if it would be or not. It's a new kind of a new day, if you will. I don't know if it's helpful to senators or not, particularly since we have 2 new senators on the committee.
Okay, let me just show you for a second what it looks like so you can
Okay.
at least understand what this is. And then we can go and look at the bill itself. So this is a side-by-side. S226 has passed last year by the Senate is on the left.
Yeah.
H81 is on the right. And what this does, which you can go through on your own, of course, if you want to, is it just highlights for you the changes that were made in H81 compared to what we passed last year in yellow.
Yeah, I'm inclined to think that we should just stick with H81 at this point, just taking us through it and helping us to understand it. And it's good to have this as a reference. But even for me personally, given that everything that happened at the end before we all went home, it's I think it just makes sense to focus on where we are now, if you don't mind.
Okay. Yep. Okay.
Thanks.
So let me grab the bill. Interesting.
I would definitely love to see that side by side. I don't know how to get a copy of it. But.
It actually is in our.
It's posted.
It's on our documents page.
Yeah.
You got it.
Okay, I think this is it. Okay, can you see that?
Yes.
Yep, okay. So for the record, Jim Demaray, we're walking through HA1 as passed by the House. And the first changes, which seem like a lot, go to how, well, before I won't talk about changes, I'll talk about the whole thing. So first of all, we have the definition of participating employee, which is a school employee who is eligible for and has elected to receive health benefit coverage through a school employer. So school employee is a very important definition. It's the people basically being represented by the labor side here, represent school employees. And what happened in the original act this was passed back in 2018 in Act 11. And the definition of school employee as passed then inadvertently omitted some employees. So this is a lot of language here. I won't go through it all right now, but basically all this is doing is ensuring that every single school employee is included in the definition, except for the superintendent, who is outside this and contracts separately with the supervisory union board. So they're outside of this, but every other employee is now here included. School employer means a supervisory union or school district. And so those are defined terms. Then we go on. Unfortunately, what we have here, we have a bill that doesn't pick up the underlying language that's unchanged. So for people who are new to this, it's hard to walk through because these asterisks represent language that's not changing, but it's not here either to talk to you about. So maybe the way to start when we come back is to go through the current law and statute just so you understand the context better. But basically what this first section does is it creates the commission and then appoints 10 members. 5 are reps from school employees and 5 are reps from school employers. The reps of school employees are appointed 4 members from the Vermont NEA and 1 member appointed by, what's the name of the labor organization that we have 2 labor organizations in Vermont, and this is the second one. I can't recall the name right now.
AFT.
But 5 members are
Is it the-
AFT. Yeah, thank
Yep,
you.
okay.
Yeah. So you have 4 members appointed by the NEA and 1 member by the AFT. And then what's here again not shown is that the other 5 members are appointed by the Vermont School Boards Association. So that's the management side. Again, lots missing here, but the HA1 amends the removal of commission members language. It used to say that members of the commission may be removed only for cause by the commission. Now it says they may be removed by the appointing authority of the member without cause. So that means that the NEA can remove its members for any reason, and so can the School Boards Association. Compensation is for not more than 20 meetings a year. There is new language here about release time. So it says the school district, the employees, a member of the commission will release that member to serve in the commission. Staffing expenses, the commission can hire staff as it deems necessary. Rulemaking authority is here. And then this language has been added. This is for, in addition to the 10 permanent members, this allows for 4 alternate members. So 2 alternate members appointed by the school employees and 2 by the school employers. The term of the alternate member will be 6 years. That's the same term as the permanent members. They can only serve in the absence of an appointed member. So they're there to observe, but if a permanent member is there, they can step in and participate. They can be removed by the whoever appointed them. If there's a vacancy, they're filled by whoever appointed them. And yeah, they can be removed without cause. So where do we have this? Hold on. Okay. That's just there's removal. They can reappoint and they can remove without cause. Again, the NEA, their members, and labor groups they're members. Funding request, this is just the 35,000 for per diem and reimbursement. And this is just in the governor to include it in his budget every year, so it's baked in when it comes over. And then there's appropriation for this year to pay that amount for per diem and reimbursement. So the duties of the commission are to determine, so let me back up. VHI offers the plans. VHI is responsible for the plans. The commission is not. So when there's those gold, silver, platinum, whatever plans are issued by VHI, the commission is not establishing the plans. They are determining the percentage of the premium in our pockets for those plans. Okay, so that's what the responsibility is to do. So the premium responsibility has to be in effect for the entire plan year. The employer is responsible for paying on behalf of its employees the applicable percentage of the premium costs. And then this is a big change here. So this here, striking out 3, what's being struck out says the premium responsibility percentages for each plan tier should be the same for all participating employees. So in the first round of negotiation under session law, the commission was allowed to have flexibility in terms of setting these percentages higher or lower depending upon income, for example, of those employees. But then it's supposed to go after that to this language here, which is basically not to allow that to be bargainable. However, this strikeout changes that back so they can bargain over the premium split for different tiers of employees. That's a big change. And then the commission will determine the amount of out-of-pocket expenses on a calendar year basis. And again, this is important. It's been struck out. But again, now with the strikeout, the commission can set different out-of-pocket percentages for different levels of employees. Okay. And then this language is new here. So it says the commission may negotiate a statewide grievance procedure for disputes concerning public school employee health benefits. So that would be grieved not at the local level. If they choose to, it's a may, not a shall. But if they set a statewide grievance procedure, then those grievances would go to a statewide grievance process. And then it says, in no case shall a school employee receive cash in lieu of receipt of healthcare benefits from one school employer while simultaneously receiving healthcare benefits from the same or another school employer. That's to avoid double dipping. And then G is new. It says accommodation shall be made for school employees whose workload is shared between more than one school employer and who may not otherwise qualify for healthcare benefits from only one school employer. The affected school employer shall determine the proportion of the shared costs of the health benefits. So if you have an employee who's employed in two different school districts part-time, they can then work out basically how to cover healthcare. Then section 5 here deals with negotiation. And what's happening here is negotiations have to begin on April 1. And they have to end with a final agreement by December 15th. We'll come on to that later on. This is backing up and saying that on before October 1 of the year prior to commencement of bargaining, the commission shall request from the parties data and information that anticipates needing, and that will be delivered by February 1. So if we use dates here for this year, this won't be in effect for this year because it's too late. But for this year's negotiation, how it would work is by October 1 of 2020, the commission would request information. The information would be delivered by February 1 of 2021, and then negotiations would begin on April 1. So it sets up the pre-process for negotiations. Now this is a new section 5A here is amending the very same section we just talked about. And that's because this goes into effect on passage. This goes into effect on December 31st, I believe. So it will be not used for this round, it will be used for the next round negotiations when they happen. So a little confusing to have a section done twice in a row, but that's why, because they have different effective dates. What this is about is same language we went through, no difference there, but what this is about is adding, as Rep. Waltz mentioned, the Labor Relations Board as a potential arbitrator. So this says that the commission shall select a person to as fact finder, talks about what the fact finder does, and then here it says the commission shall mutually agree on an arbitrator by April 5th to decide matters in dispute. But then there are two further options. So if they can't agree on an arbitrator, then they should either request the Vermont Labor Relations Board to decide all matters in dispute, or form a three-member panel of arbitrators. So you have three options: a single arbitrator as agreed, Labor Relations Board, or a three-member panel of arbitrators. Selected as follows. One, by the school employees, and this language from a list prepared by the American Arbitration Association has been struck. One, selected by the reps of school employers, and the third is a member appointed by the American Arbitration Association. And then it goes on here just to, again, reference the VLRB again. So then 2105 is about dispute resolution, and section 6 has some changes in terms of the process. So it says here that the reps of school employees and employers shall submit to the arbitrator or arbitrators their last best offer on issues remaining in dispute prior to the arbitration hearing. The arbitrator or tour shall select one of the last best offers without amendment, submitted by the parties prior to the arbitration hearing in its entirety. The parties shall not be permitted to modify their last best offers post-hearing, and prior to the issuance of the decision, the arbitrator or arbitrators, nothing shall prohibit the parties from settling the matter in dispute. And then we get into the cost side, and this is where Rep. Ross was talking to Senator Chittenden about this a bit. So it says the arbitrator or tour shall hold a hearing at which members shall submit their relevant evidence documents and material, including a cost estimate for the term of the proposal, with a breakdown of costs borne by employers and costs borne by employees. And then it goes on to say the arbitrator or tour shall issue a written decision within 30 days after the hearing, providing a full explication of the basis for the decision. It will be final and binding, and not subject to ratification. And then upon majority of the employer or employee members, they can ask for Superior Court to review if there are some misdeeds done, basically bad faith, which is missing here because it's at the stars. So section 6 goes into effect on passage. It's amending section 2105, and just like before, there's another amendment to 2105, 6A, that goes into effect at the end of this year. So this won't apply for this round of bargaining. Now, all this is doing is picking up these references to the VLRB. So a lot of changes here, but they're all basically around adding in the VLRB as an option for future negotiations. So I won't go through all that, but you can just see those references as we scroll through. Okay, and that's the end. The effective dates on those sections, they go into effect in January 1 of next year. So I said December 31st, but it's actually January 1. And that's all about having the VLRB involved in future negotiations, or an option to use. And the remaining sections go into effect on passage.
Senator Perschlick, please.
Jim, I had a question on how they decide. This is on page 8 at the bottom, going into page 9. If they can't agree on an arbiter, then they have 3 options. But it seems like if they can't agree on an arbitrator, how do they decide on which of the 3 options to do?
Let's go back and look at the language.
Like, this doesn't have line numbers, but very bottom that.
So here it is right here. So first, they try to agree on an arbitrator.
You know,
If they can't do that, then the commission will either request the Labor Relations Board or a three-member panel. And the way that the commission votes is a vote of the commission has to have a majority vote of the 5 members on each side. So they would have to vote on which way they want to go here between the VLRB or a 3-member panel.
okay, so the arbitrator has to be by consensus, but isn't there a even number on both sides?
They have even number on both sides. So in order to agree something, 3 out of the 5 members of each side have to agree to it.
So, but could we get into a situation where they don't agree on an arbiter, and then they can't agree on whether they should do the VLRB or the other 2 options? What happens then?
I guess that's possible. That isn't addressed here.
Okay, good point. Senator Perschlick?
No, that's it. That was my only question.
Jim, if you would remove that so we can just, there we go. That way I can see everybody. Thanks. Questions for Mr. Desmarais, realizing this is just a walkthrough. This is something I think we'll all have to dig into a little bit over the week, and I'll touch base to get a sense of where the pro tem is on this in terms of moving it. There was talk about moving it before crossover. So I'll talk with her and also all of you during the week. Senator Hooker and the Senator Lyons.
So this bill, even if we passed it, wouldn't affect this year's negotiations?
It would affect them this year, except for it would affect them this year, except for those provisions bringing in the Labor Relations Board as an option.
I guess what I should have said was, if we don't pass it, then things are going to stay as they are, and all of the employees will be treated equally or the same. if not equal?
Correct.
Okay. Okay. And is there a possibility of having a default to address Senator Perchlik's concern of if they can't decide on an arbitrator?
I'm sure there are ways of addressing that. I'm not aware of what they may be. But yes, I'm sure there's ways we can, you know, it's a policy question in terms of how they work.
Senator Hooker, did you have a follow-up? Senator Lyons?
I think I just forgot my question. No, it just, there's a lot here. I think that April 1st is what we heard is the deadline for beginning the process. So we passed this bill last year. I guess that was my underlying question.
You did.
Yeah.
S226, and that side by side, I showed you has the
Yes.
differences. Yep.
Yeah. So, but did it come out of the Education Committee?
It did.
It did. Okay. Well,
I believe Senator Perchlik was the presenter. I could be wrong on that. Might have been.
okay.
Yeah, last year we did work on it. I was the bill sponsor and presenter.
And then the question is also the recommendations that we're getting from superintendents and school boards is what Senator Chittenden has posted. And there are some costs, I think, embedded in that request. It's a pretty detailed request. So I'm going to have to go through and look at the bill next week and think about it. But given that this really is a short timeline to get everything turned around. So I think we should,
very short time.
We should get it completed. Yeah.
Senator Chittenden.
Just to be clear, I offer it not as an endorsement, as just something I'm trying to understand how much it's already been considered. But what I heard from representative that came to us today is that this seems to be new language. So I don't know how to dig into it deeper, but I would welcome more advice from Jim as to how that language, what implications, where it would fit, and whether or not it's worth considering.
You know, actually, it would be interesting to understand what this proposal means in terms of time and cost. Because when you ask for actuarial value, that's slightly different from asking for costs. So it's the benefit, it's the value of the specific plan that people are getting relative to other plans. And so, yeah, I think I don't know whether we want to dig that far or not. I'd just like to know how much would that cost to do during a negotiation. And then the other question I have is how frequently are these contracts, healthcare contracts negotiated? Is it every other year or every third year?
I think the first contract was for 2 years, right?
Yeah. Okay.
Yeah.
Okay. So is there any change to that in this bill?
No.
Okay.
Senator Hooker.
Doesn't it depend on I don't know how this relates to regular contracts, but if you have a contract that's for 2 years, wouldn't the healthcare piece?
Healthcare is separate now. I mean, this will bind everybody for that period of time. So then there will be cost implications for each school district and their contracts.
And a question for Senator Perchlik. Last year, when you were considering this, you didn't consider the difference in incomes. This is or did you talk about it?
We did. We did include that in S226. My memory that we wanted to make sure that they could negotiate that.
But it didn't come out that way.
Well, the bill didn't pass, but the first negotiation, they were allowed to do it because it was like, as Representative Waltz, it was something that was going to happen in the future. So they said, okay, this first time you can do it that way, but in the future you won't be able to unless the law is changed. So they came back after the negotiation and asked for that change in preparation for this next negotiation, but it didn't pass last year, so it'd have to pass this year for them to be allowed to negotiate different, co-pays based on income. Does that answer your question?
Yeah. Yeah, thanks.
Yeah, Senator Purcell.
And on the cost, cost containment, if you want to call it that, but we heard a lot of testimony about this last year, and it wasn't in the bill, but it's in the law that the arbitrator does have to consider what the cost of these healthcare plans are basically on the school boards. What's the ability of the state and the school districts to cover this cost? So it is part of the calculations. I understand some of the school boards want a much more rigorous test that they have to kind of weigh them, but it's part of the calculus now.
The point Senator Pershing just raised, what I'm trying to understand better is then that's what I'm wrestling with, but I'll do my research and homework this coming week.
Any other questions at this point for Mr. Desmarais? This is, I think we all need to have a careful look at and see what direction we want to move in and under what time frame do we want to do so.
So I'm going to stick with the concept that this is an arbitration bill, that it's not a healthcare bill, and the more we dive into premium analysis, the more it becomes a healthcare bill.
Mm-hmm,
Oh.
mm-hmm, mm-hmm.
And that it's time sensitive. If
Yeah.
April is
Right,
Exactly.
right.
just date.
Yeah. Okay. Anything else on this, or anything else that we've discussed? Okay. Thanks, everybody. It's been a great week. Got a lot done. I hope everybody has a great week. Feel free to be in touch with any questions as we move forward. I know you're all, it's not really a break, but hopefully everybody, as Senator Clarkson said on the floor today, can get a little bit of rest. So really appreciate everybody's help, and we'll see you all soon.
Thank you.
And Jeannie,
Thank you.
Senator,
Take care.
thank
Can
you.
you all hold on for a minute?
Yeah.
After